And this is BBS hearing for Thursday, August 18th, 2022.
Okay, we good, Deb?
Yes.
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Deborah Richardson, Boards Administration.
Jay Scoria, Department of License and Inspections.
Okay, anybody testifying in this, the hearing today, please raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth. Could you please respond?
Yeah,
Okay, good. Jace, put it into the record.
Yep, this is BBS case number MI-2021-003142 for 1346 Arch Street. For the record, can you please state your name?
My name is Henry Clinton. I'm the attorney for the appellant, which is Arch Street United Methodist Church.
My name is Robin Heinecke. I'm the lead pastor of the church.
my name is Russ Alexander. I'm a trustee of the church.
Is that everybody?
Thomas Rybakowski, City of Philadelphia, License and Inspections.
Okay, Tom, you want to start off and then we'll have Hank take over when you're done with your presentation?
I'm going to reserve the right to answer the opening statement as the city was not the one who filed the appeal for this action.
Okay, Hank, you want to take it over?
Sure, Mr. Chairman. Good afternoon, Mr. Chairman, members of the board. Henry Clinton on behalf of Arch Street United Methodist Church. With me is the lead pastor, Robin Heinecke, as well as the chairman of the board of trustees, Russ Alexander. So this is an appeal that we filed back in July. Excuse me, the date of the violation is July 29th. We timely filed an appeal. Basically, I believe Tom issued the violation, or someone from his department did, because of an unsafe condition. So what I wanted to do for you, Mr. Chairman, and the board was have the pastor walk through some of the slides that we have to show you the prior condition, existing conditions, and tell you what the church does, both historically and what it does for the city. And then have Mr. Alexander bring you up to date with where we are with the engineering firm on getting the plans in place and bidding the job out, if that's okay. The pastor would take probably a minute and a half, and Mr. Alexander would take 2 minutes. If that would be okay.
That's
Is
fine.
is it possible to allow me to share my screen?
Sure, go ahead.
I'd like the chance to respond.
Okay, go ahead, Tom.
In fact, I don't believe that this case has jurisdiction by the Board of Building Standards, in that this case had already been heard twice. An appeal was filed back in August of 2020 following a notice that was sent. The notice that Mr. Clinton is referencing is a final notice to correct. The initial notice to correct, or the initial notice of violation, was sent and received and appealed, but that notice was from April of 2019. At that time, the board did rule at a hearing that the occupancy was to be limited, netting was to be installed. Netting was installed under the guisement of a make-safe permit, but that did not repair the steeple. That was a temporary safe measure for debris that would fall off of the spire. As far as permanent repairs under the guisement of a permit, that's not for this board. This board has already made its decision. And in fact, another appeal was filed for the receiving of a final notice. And that hearing took place on August 27th of 2020. In fact, the board ruled, the board has denied the variance request for an additional time, for an extension of time. At that hearing, we had heard testimony that the contractor was out of the country, and due to the pandemic, they could not get entry into the States. That's back in August of 2020. This is now August of 2022. We're 2 years again, and now they're filing another appeal to the same appeals board for the same case. You do not get the right to keep filing appeals to a board that's already made has already adjudicated the case. So as far as I'm concerned and the department is concerned, we've already heard, we've already made a decision. The board does not have jurisdiction any longer.
Okay, well, we don't have any jurisdiction, then, because we made our decision, then there's nothing else for us to do. What would the appellant have to do now?
As I'm not
Lawyer?
their legal counsel, the board has already made a ruling. I can share my screen with the docket or with the ruling that took place on August 27th of 2020. I'll share my screen. As far as I can represent to the board, then I suggest that the board, there's no action by the board for today's hearing, in that this has already been adjudicated. They can seek another line from their legal counsel, but as far as represented by this board or represented by the department, I don't see how you have jurisdiction over something you've already adjudicated and ruled on.
Does the church have the ability to go to court with this? What's their? I'm sure Hank knows what their next step is, but what is their next step?
Mr. Chairman, I'd like to clarify one thing that was stated. I think it was, I forget the date, but it was a 2020 date where the representative from L&I suggested or stated that the contractor was out of the country. I want to make it clear that at that hearing, we stated that the contractor that we were seeking to do the netting project was out of the country. It's not the contractor to make the repairs. Currently, we are awaiting construction documents from our engineering firm, which is CVM Engineering from King of Prussia. They have been laboring for almost a year and a half to create construction documents because of the complexity of this project, notwithstanding the scaffolding that needs to be erected and the repairs that need to be made both interior and exterior to the steeple to make it safe. This is probably a $4 to $5 million project. It is complicated, it is long-term, and we're in the process of raising funds to complete this project. We actually are a recipient of a RACP grant of $1 million. We've raised an additional $500,000 for soft costs. I understand and completely understand how important it is to move in a forthright way with this project, but it is going to be a long-term project. At this point, all the street protections are in place. We've complied with everything that we've been asked to do. And yes, the order to correct is still outstanding. We understand that. And we are moving as forthrightly as we can to comply and to get this thing taken care of. But it is going to take a long
Pastor,
time.
let me explain something to you. This, first of all, you have 1.5 million, and actually, I'm just trying to get a grasp around this. To raise the other 3.5 million might take you years. I mean, you did the netting and all, but you didn't fix the steeple, and
That's
the
correct.
danger's still there. So again, there's nothing else we can do with this board. We made our decision, and you know, I don't know what the next step for you guys is. And the thing is that we can't give any more extension of time in repairing the steeple. So I don't know if there's another line that you guys can take, but again, you got to understand something. Our group here at the board, we can't, on our watch, we can't let something come down. I know you have the netting and all, but that might not even be as safe enough for the people underneath. And the thing is, if something happens there, you know, I can't, in all honesty, to say you take as long as you want to get this done. You know, because if someone gets hurt, it's on me and on the board here, and I can't let that happen on my watch. And no disrespect to you or anybody else, but you got to take another step, and it's not with our board.
Well, Mr. Miller, can I address Tom? Tom, what we're trying to do is basically stave off any enforcement action by your department. And we're trying to show you that we're acting in good faith to get things done. I agree with Mr. Miller. It's not the fastest thing we've done, but we were in the pandemic for a while. We had a firm from Germany was going to come over, then they didn't come over. We couldn't get anybody local to do the netting. We had the netting done in the dead of winter. It was literally snowing when the steeplejacks were up there. We have a $145,000 contract with a firm from King of Prussia to do the engineering drawings. I mean, they're doing laser drawings, they're doing internal drawings. They put a drone inside the spire to take measurements and dimensions. They put a drone on the outside. So we're going to get the money. We have the state senator behind us, the state representative behind us. Mark Squilla has his office is involved. You know, we have contracts with the city to house the homeless in the basement. We just got a really good decision from L&I to let us put a ramp in on the outside so we could have people have wheelchair accessibility to the church. So, I mean, I'm not trying to throw my client at the mercy of L&I or the board, but they are spending significant dollars to try to bring this place into compliance. I mean, it's older than City Hall. The building's older than City Hall.
I get that, Mr. Clinton, but what I'm saying is this isn't the forum to petition that. We've already adjudicated. And I understand and I sympathize with you, the financial end and the stability in the community that your place of worship and your clients do with the community. I get that. But this isn't the forum. The forum is a different, and you know that. This isn't the forum. This is just to, and you said it plainly yourself, this is to stay any enforcement action from L&I. This isn't the forum. So as far as department is concerned, this isn't the forum to ask for additional time. We've already adjudicated it and been done.
Tom, just a clarification. Was the last appeal was to have additional time in order to install the netting, I believe. And which ultimately we rejected the netting. I'm not sure the timeline of all this, but the netting was installed and that was done.
Correct.
At that point, was there anything in their original appeal that was a violation for not actually doing the repair work? And was that technically part of what was previously adjudicated? And what I'm sort of getting at is the appropriate thing at this point that a new violation be be given if the department felt that was appropriate, and then that would be something that could be appealed.
So to answer your question, sir, the violation that was originally written April 16th of 2016 under case number that is on the appeal paperwork today on 680090. The violation is for the location is exterior walls are not anchored to supporting or non-supported elements. And then it gives the location, periodic facade inspection by engineer has found damage to east spire. So it names the east spires specifically in the violation that it needs to be repaired. The appeal did reference the.
This lady Samantha Drake from 1822 East Monumental called.
Let me get the first.
Tom told her that they would only be using the excavator to secure the beams, but she said she's watching them use the excavator.
Who's that?
Off the dock.
Give me 1 second.
Tom's in the office.
Okay, is that what the?
Tom, you're on mute.
Tom, you're on mute, Tom.
Tom, you're on mute.
I'm sorry. So the first hearing that was heard by this board was heard on August 8th of 2019. That case was continued for 8 weeks for additional information to be submitted to the board. And then there was, the appeal hearing took place October 10th of 2019. At that time, the board recommended granting an extension to complete the following. Sidewalk is required to be closed off immediately. Parking is required to be closed off on adjacent lanes on Arch Street and Broad Street, providing 2 protected entrances into church, maximum occupant load of 499 persons, 2 exits. If 3 exits are provided, minimum occupant load of 800 persons. Provide structural netting on Spire by April of 2020. Then there was the additional request for additional time because the netting had not been installed. And that's what brought us in to the third hearing. The third hearing was a request for additional time to install the netting. We knew that the timing wasn't what we knew that they needed more timing for the netting, but the appeal was filed to the board because we had already had a hearing. The board already made their ruling and declined the request for additional time. That doesn't solve the violation. The violation is still for the unsafe case against the property for the Spire.
Well, Tom, we have another violation, right, that was issued. So typically they get appealed. So
No, you have another notice that was issued to you. It's the same notice. It's the same case number.
Right, it is the same case number, but it's
No,
dated.
you'll
July-
notice that the notice from 2019 is the initial notice. The initial notice makes reference to the right to file an appeal. You'll notice your final notice that you're speaking of from last year, that does not have any language that there is an appeal to be filed on a final notice that is sent out.
Well, what I appealed was, the title is Unsafe Structure Notice of Violation Warning, dated July 29th. That's a notice that I have. And
Yeah.
it says exterior facade roof.
Yeah, what's on it says final notice up at the top of that notice, correct, sir?
Not on this document. It says, for additional information, visit our website. And then it says, unsafe structure.
No, that's
that's
the
the document.
posting.
But I know,
That's
but
the posting of the property. That's the posting of the outside of the property.
okay. And that's the document that I attached to my appeal. So
That's
that's
not
how we
the-
ended up.
That's not the notice that goes out via first class and certified mailing.
Well, I mean, that's the appeal. Look, bottom line is, I think we both want the same thing. I mean,
Bottom line is that this is the wrong venue. The bottom line is that you said it yourself. You filed the appeal to stay any enforcement action by the department.
correct.
This is not the forum for that. The
Well,
board has
maybe-
already made its ruling. I'm gonna rest and turn it over to the hearing master.
Okay.
Okay, so Hank, the only thing I can see right now is that you have to go to the proper board to take care of this because we don't have any authority now.
Tom, can I talk to you offline? Can I call you after this hearing?
Yes,
What number should I use?
215-686-2583.
Yeah, maybe we can have a sit down or something. None of us want to waste time in litigation, especially the church. They don't have the resources to do that. If we need to sign a consent agreement or whatever, I'll talk to you afterwards. Thanks a lot.
You're
That's
welcome.
good. Okay. Sorry, guys, but Tom, all right, you and Hank can get together and decide what's the next step. Okay.
Thank you,
Sounds
Mr.
good.
Chairman. Appreciate it.
All right, guys.
All right, thank you.
Appreciate your time, everybody. All right, talk to you.
Thank you.
You're welcome.
Thank you, Deborah.
You're welcome.
Okay, Hank. Okay.
Hold on.
For the voting form, should I just say no longer under BPS jurisdiction, or should I not even do it?
It's not, if you want to put something for the file, it's not in our jurisdiction.
So who would,
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member?
John Dimes, Fire Code.
Deborah Richardson, Boards Administration.
Jay Scurria, Department of License and Inspections.
Whoever's going to testify in the hearing, please raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth. Please respond.
I do.
Okay. Jace, take it away. Put it in
All right.
the record.
Yep, this is BBS case number MI-2022-004885 for 212 South 24th Street, Unit 2425. For the record, can you please state your name?
Jeremy Lecomte of Harmon Deutsch Oler Architecture.
Okay, Jeremy, you're presenting the case. Go ahead.
Okay, may I share screen?
Yeah, absolutely.
Okay, can everybody see my screen?
Yes.
Okay, so the site is 212 South 24th Street. It's located just east of the Schuylkill River here. You'll see the park along the edge of the river and then the rail lines here. This is our property. Let me go back. One thing that I want to point out is, all right, so first of all, this is a condominium complex. My client owns the condominium at the corner that I'm circling here. Yeah, let me go back one. So my client actually owns a condominium in the second from the end building and was recently able to purchase a condominium in the corner building here that I'm hovering over.
Okay.
To essentially expand his residence. And what we are here for today is we're proposing some new window openings that essentially provide additional light and air and views of the river from the condominium in this corner. You'll see from the property line image that we're looking at here that there is a slight difference in the rear property line of our adjacent property compared to where the property line, it's jumping around a little bit, the rear property line of the adjacent property compared to the rear property line of our property. This is just over 22 feet, the difference there, which happens to fall at the rear wall of the dwelling unit that we're talking about. So I'm going to give you a little more context here. So this is an aerial photo of the condominium complex. Again, this corner unit here is the one in question. And this is view from the Walnut Street bridge of that condominium. The upper two floors of this corner building are the condominium in question. You'll see that there's already existing windows on the north wall here, as well as the west wall, which are up against that shared property line. We're proposing some additional openings on the north wall. Excuse me, the north wall that I'm highlighting here. And I will flip to that now. So I've highlighted those additional. At the third floor, there's actually an existing opening in this location, but it's smaller than what we're currently proposing. So this one is more of an enlarged opening, whereas this opening at the fourth floor is entirely new. And then we have a mezzanine level that's above the fourth floor, where we're proposing a large new window opening. So essentially, jump back to this. We're continuing the existing condition. There's already openings proposed in this or existing in this location. We're proposing an expansion of them. The windows that we're proposing would all face properties which are highly unlikely to be developed because we're fronting the regional rail lines essentially and the river. Even if somebody were to take the parking garage on the adjacent structure down and expand it, the depth of their property would not encroach the windows that we're proposing in this corner property here. So we're seeking relief from the board essentially to provide additional light and air and views to this corner dwelling unit. The existing construction is all masonry exterior bearing walls. We have non-combustible exterior walls already and at least 2-hour rating, exceeding 2-hour rating of our exterior walls as it exists currently.
Jeremy, do you have any photos of what's on the ground right next to the parking garage and in front of that north wall?
Next to the parking garage?
like, look at this picture you're taking is from a bridge. Do you have any pictures looking down so you can see what's in front of that white wall and next to the parking garage?
It's essentially, I don't have photos of it, but no, it's essentially some greenery in here between the rail lines and the apartment complex that is all part of the properties owned by CSX for the rails. Can,
Okay.
Okay.
so
There we
you can-
go.
Yeah, you can kind of see
Yeah,
that.
other,
Okay,
That's the greenery beyond our property line. There's a plaza deck in the center of this condominium, which is above the shared parking garage, which is essentially just under this plaza deck.
Mhm.
anybody got a problem with it?
No,
Okay.
no,
Amy?
were there also openings being cut in what was a party wall that we have to discuss, or in between the two houses?
No,
Okay.
I'm not sure why that got you in the refusal, but there was a point in time where we were essentially creating breaches between the current dwelling unit and the new
Right.
dwelling unit.
Right.
But we took a path of consolidating those two dwelling units so that the breach is no longer a conflict.
Okay,
Yeah, the refusal was actually updated to remove that item, so I think the old refusal was actually captured in that, but they changed
Okay.
the scope of work. So, okay.
Okay, all right. All right, everybody good with it?
yeah,
Okay, good luck, Jeremy.
Thank you for your time.
All right, guys, take it easy.
what,
We're back on the record, Wayne.
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ed August, board member.
John Dimes, Fire Code.
Deborah Richardson, Boards Administration.
Jay Scaria, Department of License and Inspections.
Okay, anybody gonna testify in this hearing, please raise your right hand. Swear to tell the whole truth and nothing but the truth. Please respond.
I do.
Okay. Jace, you want to take it put it into the record?
A sec. Okay, this is BBS case number MI-2022-005103 for 419 Bainbridge Street. For the record, can you please state your name?
Carl Primavera, Primavera. I'm with Claire Harrison, and I'm the attorney for the applicant, which is HR Bainbridge LP. And Peter DeLulo is the principal. He's on the line and sworn. And Michael McCluskey from Bernardin is the architect. And his colleague, Christy Simchick, is also on. But we envision most of the discussion will be my introduction, and then Michael and Christy answering any specific questions, and obviously ownership is available for any additional questions.
All right, whoever wants to present the case, go ahead.
All right, thank you. So basically, this is a parking lot where we've proposed mixed-use project, 2 commercial spaces on the ground floor, and then apartments above. The issue which popped up here is the question about the roof deck. So as you've seen in the materials, the building itself is, in terms of where the apartment units are, floors 2 through 7. And we're basically in a position where we don't have a problem with the 75-foot height limitation. But we do have a roof deck, which would be above that. So our interpretation and understanding of the code, and even other projects where Bernardin has been involved in the city of Philadelphia, is that the occupied roof is not occupied floor. So we believe that the provision that's been cited is not applicable to what our conditions are. And then additionally, we believe we have more than adequate fire protection, fire safety. We have 2 means of egress from the roof. The building's fully sprinklered. So there's really not a situation where people are occupying as a residence. They may be standing on the roof, but it's not the kind of occupied area that we believe the code provision was meant to cover. So that's really our position. One, it's a question of interpretation where we feel that we have a legitimate interpretation. We've also attached to our appeal a very interesting article by a well-known writer with the building code industry. And he basically says, an open occupied accessory residential roof deck is not a floor for these code requirements. And he's the one that came up with the statement, occupied roof is not occupied floor. And that's really the code issue. So Michael, as the architect, and Christy, do you have something more to add or some further explanation about your prior experience with this provision?
Yeah, I don't mind jumping in. So Carl, what you're referring to actually just isn't an article. That's a code interpretation from Christopher Reeves, who's the director of architecture and engineering for the International Code Council. And, this isn't just something he wrote. This is their interpretation of how the code is written. Bernardin is also under construction on a project at 417 Callow Hill Street, which has a roof deck, 5/2, very common construction type, 5 stories of wood over 2 stories of non-combustible construction, with a roof deck with 590 occupants, 2 means of egress. That's been permitted through the city of Philadelphia with wood frame construction. The highest occupied floor level, 74 feet 8 inches from the lowest level of fire department access. We are at 71 feet here and feel that the ICC is very clear on the intent of this code and has gone as far to offer a ruling that Mr. Reeves has put out there, understanding that the city of Philadelphia has a different interpretation. However, it is not consistent in L&I's action on permits, and we feel, and then most of you don't really care what happens in other jurisdictions. There's any other jurisdiction we've worked in have been able to get a 5/2 with a with the roof deck approved. So we feel this is inconsistent within L&I. We don't feel like this meets the intent of the code, and we feel that the information we provided clearly states that.
So Michael, how much I think it's a 25 square foot roof deck?
No, it's 166 occupants. So I don't know, work that backward. A3 occupancy, 15 square foot a person. Christy, you may have that math with you there, but maybe 25 by 25, roughly, I think is maybe what you're referring to, Carl.
Yeah, I'm just trying to, the size of the roof deck, we know the size of the roof, but what percentage would you say is the roof deck?
It's a 2,500 square foot roof deck.
All right. So, my position there is that it's not oversized. We believe it's got, as you point out in the plans, tremendous access to 2 points of egress. The building's sprinklered. So we think it's very much within what we would call the comfort zone of these types of buildings in the city and elsewhere. It's a wonderful amenity for people, to get some fresh air. And we certainly designed it with that in mind. And it would be a real hardship if we weren't able or allowed to use it, because there's no way we can retrofit the design or the the engineering.
Carl, I'll talk another hardship, just real quick, very high level here. I'm not, no offense to Pete and his team, and Harvey, great clients. Hardships here more on us. I'm going to tell you guys right now. I've got a set of clients here that I've designed a building for that very clearly fits the intent of this code. I'm doing it in many other jurisdictions, including the city of Philadelphia. And we have an L&I inspector who's coming off and telling us it's not permitted by code when it clearly is. And the ICC has clearly defined this in the code interpretation that they've published. So, the frustration and I think the hardship here is on a design professional who is required, to interpret the code. And we feel like we, take a lot of immense pride in doing that. And we're rolling this out for a client who has a lot of money with our organization and others. So From a hardship standpoint, this is on us, and we think it's very clear. And now, we have to spend our independent time going here and proving this when, the ICC very clearly has issued a ruling on this. The city of Philadelphia is just not open to that interpretation, we feel like.
And the key thing, and I'll just close on this, it always comes down to safety. And we believe that the condition that we're proposing is safe. Elcor is the parent company. And Pete, if you want to talk about some of your projects, 1919 Market, and it's a better than first class developer, and they are at the highest levels of responsibility. So Pete, tell us a little bit about Elcor.
Yeah, no, I appreciate that, Carl, and nice to meet everyone. In the city, we've developed 1919 Market Street with Brandywine Realty Trust. We're currently under construction on a 31-story tower in Society Hill. Our partners are large pension funds. We take great pride in ESG, integrity, safety. We've been doing this, throughout the Mid-Atlantic and Northeast for nearly 50 years now. So it's, by no means are we trying to, get around code or do something that isn't reasonable, safe, or right. This is more, as Mike said, we've designed this building for over a year now. We have construction lenders, partners, a lot of money, on the line for something that, quite an amenity given the, urban footprint of this location to provide outdoor space, particularly on the heels of a pandemic that we've all been through. I mean, it's really quite an important amenity to the project. So it really
So
would
Pete,
be. a hardship.
would you let your family live in this building with this condition as described?
Well, you put me on the spot, Carl. No, but I mean, it is, it's a tremendous amenity, to get that fresh air, like I said, particularly coming off of, pandemic like we have. This is wildly meaningful for the project, and we have, investors, partners in the Spear family, and our lenders that are relying on this amenity that we believe is as of right.
And you wouldn't even seek relief if you felt it was in any way lowering the standard of care or fire safety?
No. Look, I mean, our partner on this, along with the Spear family, is California State Teachers Retirement System. We don't have the ability to bend, any rules. That doesn't work for our company. It's never been what we've done.
All right. So I don't have anything further. If the board has questions, Michael's available, Peter's available, I'm available, Christie's available. Bob
I have a question.
and Harvey Spear available.
I have
Yes.
a question. I'm sorry, I forgot the guy's name that was did the engineering of the building.
Michael.
Michael, you said you had two other buildings similar to this in the city of Philadelphia?
417 Callow Hill Street is permitted with a 490 occupant roof deck above a 5/2 structure. It is currently under construction.
But what's the elevation of the roof?
The highest occupied floor elevation is 74 feet 8 inches from the lowest fire truck access point, which would put the roof deck somewhere in the neighborhood of 85 feet.
Gotcha. Okay.
Real quick, this is Lieutenant Dimes. My 2 cents on this, and I'm a kind of an advisor. I'm not on the board. But I believe the interpretation that you guys have presented is accurate. I don't think that's where the code's going to be going probably next code cycle. When it comes to occupiable floor, to me, if you're standing on something like a roof deck, it's occupied. So you have travel distance, all this type of stuff. However, reading the code and what it says, it doesn't seem to meet the definition of a floor. It doesn't have a roof over it, doesn't have walls. So even if it's occupiable, however, I think the city of Philadelphia and possibly the rest of the country and the ICC may have a different interpretation of the next code cycle. But based on my reading of it, whether or not I agree or disagree with it, your presentation, I agree with what you were saying. I don't think it meets the strictest of definitions of a occupiable floor because of the way, what it is. It's a roof deck. So that's my opinion.
Just
Thank
one
you.
thing to add to that, and I agree with what John just said. The next IBC that's issued may in fact be very clear and forbid this. And in addition, and I don't know where this will go, but my understanding is the city may be issuing a bulletin, a code bulletin that is specifically coming down with an opinion on this, which, in the future, it obviously can be appealed, but it will be, something
Yeah,
that
this was
is
in
made clear in
adopted by
advance.
the Philadelphia Building Code. Again, Philadelphia Building Code does not say anything about this. They
Yeah.
adopt the 2018 building code in its entirety. And if they want to adopt this with a ruling within the building code, that's where it needs to happen, not in an FAQ that is issued on June 6th of this year with just an opinion, right?
Right, but they also do issue code bulletins that supplement the code when they
Correct, yep,
adopt it.
correct.
You know,
If it's-
and
if it's truly a
that has
bulletin,
not happened yet
Yep,
in this.
it
case.
has
It has-
not happened. Yep, the only ruling that has shown up is an FAQ answer on, on their
Yep.
FAQ website, right?
Yeah, I would say this, once we know the rules of the road, we comply. I think Michael's earnest concern is, as a professional, and Ted, you did this for a long, long time. I don't want to make you old, but you did it for a long time. You follow the rules and you want to do right by the client, you want to do right by the city. And then all of a sudden, if you feel blindsided, it's a hard thing to take. And I think that once everyone knows the rules, we're happy to follow them. We build it in upfront. So look, we appreciate your expertise. We appreciate your time that you devote to this board and to your public safety responsibility. But seriously, speaking for myself, I have a 30-year-old kid. He's not a kid, young man. He'd be happy to be in this building if he could afford the rent, Pete. It's not going to happen. And I would feel comfortable living there with my wife. So we don't think there's any degradation of life safety. We think, quite frankly, this is a safe environment and a great environment. So thank you.
On my part, on my behalf too, is the thing is that, again, I believe if it was a code and you were violating a code, we would turn it down. There's no code. I don't want to hear a frequently asked question. That ain't a code to me. It doesn't mean anything to me. So again, I have to agree with you guys. I think the definition, you're within your rights to do what you're doing, and whether I like it or I don't like it. The thing is that you're, in my opinion, you're in the right to what you did. We can't define what a floor is, and is it something with a roof? Is it something with walls? And it's not up there. So I happen to agree with Ted and also John. So that's how I feel in your guys' favor.
Thank you.
Okay. Does do we have anybody, Amy, do you have a problem with this? Does anybody?
No, I think we're going to end up saying that the refusal was written in error, though.
Yeah, fine.
Yeah, it won't be a variance. It will be.
Right, it won't be a variance.
Yeah, there's no need for a
That's
variance.
fine. That was Michael's position all along. As lawyers, we always ask for alternate relief, but quite frankly, I agree. Why set a precedent if, let's just say the code is the code, and if there's a
code's the
new
code.
change, we'll adapt to that.
Yeah.
2024, you ain't gonna go back and change everything in 2024. That'd be ridiculous. And the code ain't even here yet. Who knows it's gonna pass? So whatever. But again, everybody's good.
Thank you.
Aim, Ted, myself,
Yes.
we're good with it.
Okay.
Guys, good luck, and you argued a great point. Thank you.
Thank you very much.
Thank you all very
Thank
much.
you very
You
much.
got
I
it.
appreciate your time.
Okay.
Thank you.
guys.
Guys, I gotta run into the thing that the ceremony's starting right now.
Good luck, Wayne. Go get them.
Okay, thanks, guys. Appreciate it. Talk
Thanks.
to
Take
you
care.
then.
Have fun, Wayne.